America's most popular rifle is on the chopping block, and the Supreme Court just took a major step toward deciding its fate. Picture this. What if the most popular rifle in America, the AR-15, was suddenly declared not protected by the Second Amendment? What if high-capacity magazines were banned across the country? This is not just an imaginary scenario. Right now, the Supreme Court is considering whether to take up this exact question. The question is simple but important. Does the Second Amendment protect your right to own AR-15 rifles and standard magazines? Today, we got important news about these cases. Let me explain what happened and what it means for gun rights going forward. Before we dive in, I want to ask you to subscribe to the channel if you find this content valuable. Also, please check to make sure YouTube hasn't automatically unsubscribed you. This happens sometimes, and we don't want you to miss important updates. I also want to thank First Form, one of our main channel supporters. First Form is an excellent company with an amazing culture. They support freedom, America, and the Second Amendment. If you want to get healthier and need quality supplements, check them out using the link below. Right now, if you order through that link, you can get a free 5-pack of protein sticks. I highly recommend them. So check out First Form using the link in the description. Today, we're talking about two critical legal challenges that went before the Supreme Court last Friday. These cases deal with bans on rifles and magazines. We now have new information about what happened. The first and most important case is called Vermont versus Cook County. In this case, individual citizens and gun rights organizations like the Second Amendment Foundation are fighting against Cook County's law. This law makes it a crime to sell, transfer, or even own so-called assault weapons. The people challenging this law are trying to use recent statements made by Justice Kavanaugh. Last term, the Supreme Court refused to hear a case about Maryland's rifle ban called the Snope case. When that happened, Justice Kavanaugh wrote something important. He said that very soon, the Supreme Court would need to address the rifle ban issue. He specifically stated this would probably happen within 1 or 2 terms. The people bringing this case believe their challenge should be the one the Supreme Court uses to keep that promise. Last Friday, the Supreme Court held a private meeting called a conference to discuss 2 things: the rifle ban issue in the Vermont case and the magazine ban issue in a California case called Duncan versus Bonta. Today, we got an update on both cases. Both have been relisted for another conference on December 13th. This is happening very soon. This relisting could mean several different things for the future of these challenges. Let me explain what's happening in detail. Let me walk you through the history of how this case reached America's highest court. Back in 2021, gun rights supporters filed a lawsuit in federal court in Chicago. They challenged Cook County's ban on AR-15 rifles, arguing it violated the Second Amendment. Then in 2024, while this case was still working its way through the lower courts, Illinois passed a statewide ban on assault weapons. This law is called the Protection of Illinois Communities Act, or PICA for short. We've discussed this law on the channel before. The state law covers much of the same ground as Cook County's ban. Around the same time, a federal appeals court called the Seventh Circuit decided another case called Bevis versus Naperville. In that case, the court upheld Illinois' statewide ban. The court made a controversial ruling. They said that AR-15 rifles were too militaristic to be protected by the Second Amendment. According to their logic, any firearms that are useful in military service can be completely banned by the government. Because of this Bevis decision, the lower court hearing the Cook County case felt bound to follow it. The district court judge ruled in favor of Cook County and upheld their rifle ban. The judge issued what's called a summary judgment, which means they decided the case without a full trial. In 2025, right after the Supreme Court refused to hear the Snope case from Maryland, the Seventh Circuit Appeals Court officially affirmed the lower court's ruling. The appeals court relied heavily on the Bevis case. They treated AR-15 rifles as basically civilian versions of military M16 rifles. Because of this, they said AR-15s fall outside Second Amendment protection. Now, the gun rights supporters are asking the United States Supreme Court to step in and resolve this conflict. They want the Supreme Court to decide once and for all whether Americans have a constitutional right to own AR-15 rifles and similar semi-automatic firearms that some states are banning. Cook County recently filed their response. They're asking the Supreme Court to deny review and refuse to hear this case. Cook County makes several arguments for why the Supreme Court should not take this case. First, they claim there is no circuit split on the rifle ban issue. A circuit split happens when different federal appeals courts disagree on the same legal question. When there's a circuit split, the Supreme Court is more likely to take a case to resolve the disagreement. Cook County argues that all the appeals courts that have looked at this issue agree with them. Second, they claim this case is a poor vehicle for Supreme Court review. They say the people challenging the ban failed to follow basic court procedures. Specifically, Cook County argues that the challengers skipped an important process called discovery, where both sides exchange evidence. Cook County says the challengers offered no proper evidence to support their claims. In other words, the county argues that the gun rights supporters were in such a hurry to get to the Supreme Court that they didn't properly build their case with the evidence needed for Supreme Court review. Third, Cook County argues that the lower courts were correct on the legal merits. They believe the rifle ban is constitutional and lawful. In summary, Cook County is saying this case is procedurally flawed, legally settled, and not the right case for the Supreme Court to use to address this important constitutional question. At its core, this case asks the Supreme Court to finally do what gun rights supporters have been requesting for many years. They want the court to take up a state rifle ban case and strike it down as unconstitutional. The Duncan magazine ban case asked the same thing for magazine capacity limits. Both cases went to the Supreme Court's conference last Friday. The Vermont rifle ban case and the California Duncan magazine case were both discussed by the justices. You might remember that the Duncan case already went to the Supreme Court once before. After the Supreme Court's major Bruin decision about gun rights, the court sent the Duncan case back to the lower courts to reconsider in light of Bruin. This is called grant, vacate, and remand. However, like other cases sent back after Bruin, the Ninth Circuit Appeals Court didn't properly apply the Bruin decision. Instead, they upheld California's magazine ban again. This led to the Duncan case returning to the Supreme Court once more. Today, we learned that both the Vermont case and the Duncan case have been relisted for another conference on December 13th. You might be wondering why it matters that the Supreme Court is relisting these cases and why this is significant for understanding what might happen. The answer lies in Supreme Court statistics and patterns from past cases. Data shows that a case has much higher odds of being accepted for review by the Supreme Court if it gets relisted at least once. Here's the key point. One relist is not a bad thing. In fact, it's often the best case scenario for these types of challenges. According to Supreme Court data from the 2016 to 2020 terms, between 31% and 43% of petitions that were relisted at least once were eventually granted review. Additionally, between 66% and 75% of all cases that were granted review have been relisted at least once. This fundamental truth is important. A case relisted just one time has a much better chance of being granted Supreme Court review than a case that is never relisted. However, I need to point out something equally important. All the data shows that multiple relists are actually a bad sign. When a case gets relisted 2, 3, 4, or more times, this typically means the case will be denied review. A recent example is the Snope rifle ban challenge from Maryland. That case was relisted multiple times, and the Supreme Court ultimately refused to hear it. The data clearly shows that a case becomes less likely to be granted review if it's relisted twice, 3 times, 4 times, and so on. The more times a case is relisted, the lower the odds become for the court to agree to hear it. Multiple relists often indicate that the case will be denied and that one or more justices might be writing a dissent or statement about why they disagree with the decision not to hear the case. So where does this leave us? These cases being relisted once is not a bad thing. This is actually a positive sign based on historical data. However, if we start seeing these cases get multiple relists, 3 or more times, that would be a strong indication they will be denied. At best, one of the justices might write a statement or dissent explaining their position. Up to this point, the Supreme Court has avoided taking rifle and magazine ban cases. Some critics say the court has treated these issues like the plague, consistently refusing to address them directly. We will know very soon whether Justice Kavanaugh's statement and promise that the court would take up this type of issue within a term or two was actually sincere, or whether it was just another empty promise. The next conference is December 13th, which is coming up quickly. That's the current situation with these critical rifle and magazine ban cases that went to conference last Friday. They have now been relisted for December 13th. All hope is not lost. One relist is not a big deal and can actually be a positive indicator. However, we will be watching the Supreme Court closely going forward. We'll be monitoring the order lists and watching what happens after the next conference. If these cases start getting multiple relists, that would be a bad sign for these challenges. As we get more information and as things develop further, I will keep you updated. If you found this video helpful and want to support the channel, one of the best ways to do that is to like, comment, and subscribe. You can also check out the other videos on screen that YouTube thinks you'll find interesting. Thank you so much for all your support. And remember, this nation was built by armed scholars, and this nation will be maintained by armed scholars.